Do you still have to pay alimony if your ex is now living with a new partner? This is a terrific question. My name is Akiva Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're continuing our video series designed to educate and inform the public. So please subscribe to our channel. It's a very good question whether or not the fact that somebody's living with somebody else means you get to stop paying alimony. Cohabitation in and of itself could affect alimony, or it could not affect alimony. The courts are going to look at shared finances and living arrangements. Alimony is sometimes, the provisions are set up so that they specifically say if you cohabit with somebody else or if you remarry, the alimony stops. It might say something like that. But remember, for the most part, alimony has a strong need component, meaning that the court gives it because you need it. Clearly, if one can demonstrate that the need component is no longer raised and the alimony was based on need, the court may very well modify the alimony. It's going to be important that you gather appropriate proofs. Just because you're living with someone doesn't mean your needs are taken care of. Perhaps the living arrangement is such that there's a splitting of bills and he takes care of his bills, you take care of your bills. So really, you don't benefit in the financial way from living with that person. Therefore, it wouldn't necessarily impact the alimony. I will warn you about one thing. You may think that the judgment says that I can stop paying if they cohabit with somebody else, and therefore I'm not paying and blah, 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 and it's cut and dry. Well, let me give you a piece of advice. Don't stop paying the alimony until such time as the court tells you you can stop, okay? Because even if you think that the judgment triggers and you don't have to pay alimony, you still got to pay it until the court says otherwise, because that's a court order. If you think that you don't have to pay it, then you file an immediate motion to stop it. And you ask the court for a temporary order stopping it pending the final hearing or something like that. You can do those kind of things and ask for it. Maybe you'll get it, maybe you won't. But you don't want to be paying alimony when you don't have to. You don't want to not pay it when you do have to. Guess what? When there's a standing alimony order, that's a situation where you have to. If the court finds, as of the date of your motion, that you were not obligated to pay because the need isn't there anymore or whatever, the court can order that the alimony terminates. The court can also order that, any alimony paid in the interim gets paid back to you. The court can do that. Whether it will or not, it's a different story. It's going to depend on the circumstances. But it's a mistake to take the law into your own hands. It's a mistake to, just stop paying something because your interpretation of the law is that you don't have to. So let's not do that, okay? Do the right thing, file your motion immediately, get with your lawyer immediately. And if you're going to say, well, I didn't want to hire a lawyer because I didn't want to pay the extra money, so I just stopped it on my own, don't be surprised if the other side files a motion, told you in contempt for not complying with the order. And even if the court after a hearing says, you know what, I'm going to order that the alimony stops from this point on, it doesn't mean you'll be relieved of the obligation to pay while that order was still in place. So do things the right way. Don't be penny smart and dollars foolish. If you have any questions about that, reach out and we'll be glad to help you out.
248-588-3333. 248-588-3333.